Larry, we've got an excellent episode today. The Bonesman in Chief is back at it. You've brought my attention to a very important case. How you doing today, Larry?
Doing well, thank you, Chase.
It's good to see you. You're
By the way,
looking well.
I won a very big victory for Laura Loomer. So I don't know if I told you that,
You did.
but her legal malpractice case against Ron Coleman, against the Dillon law firm, against the Mandelbaum law firm was sustained. It's going to go to trial. And there's a story, of course, about that because she was forced to pay, thanks to this alleged malpractice, over $140,000 in fees to CARE, if you can believe that, an organization that was named as a unindicted co-conspirator in the Holy Land Foundation years ago, criminal case, who has been linked to Hamas. So this is a very, very important case because Ron Coleman, uh, as we allege, committed major malpractice, and this will be going to a jury relatively soon.
It's really great news, Larry. You know, I am somewhat familiar with the case. Obviously, everybody knows I'm friends with Laura. We've spoken about this in the past. I'm not an attorney, so I haven't given her any advice, and I don't know the details. But it's interesting to see how various news outlets attempt to smear Laura and act like it's somehow unusual to sue an attorney for malpractice. My personal opinion, from looking at the facts in the public domain, is that I do believe there was malpractice. So congratulations on this move forward in the case, and I think it's going to go well for Laura.
Well, it did. And of course, we also have the lawsuit. This is in my private capacity against Bill Maher. And Bill Maher is fighting tooth and nail to avoid his deposition from coming out in the public record. He doesn't want it to come out for obvious reasons. I'm not going to get into the specifics because it's still under seal. But we won that motion to dismiss too. And the court ruled that we had properly pled that it was defamation per se, which was to harm Laura's moral character and her business endeavors. Of course, we know what Maher did is that he published to millions of people that she had had sex with President Trump behind the back of Melania and committed adultery. Now the guy is, sucking up to Trump because he realizes that that gives him a bigger audience. But he is just a terrible, terrible person. And once that deposition comes out, people can judge for themselves.
Absolutely. And congratulations again, Larry. I think a lot of people like to malign me and Laura and you. People don't realize how difficult it is to win these kind of victories in court, particularly when you're on the wrong side of these leftist courts. We're going to be looking today. It's crazy, too, because I think people are going to be surprised by this case, Larry. And thanks again for bringing it to my attention. This is not exactly to do with Black Lives Matter, but yet it has to do with the concept of Black people's lives actually mattering, but it steps away from the political rhetoric of that organization. Do you want to explain to everybody exactly what this is about?
It's a very important case. It's called the Douglas case. And, I'll put it up on our website at freedomwatchusa.org. It also, there you have it right there. You can see the case number and all. It's a landmark case because historically, the concept of discrimination as contained in the Constitution deals with sex, national origin, religion, and and those kinds of things. It never was extended into a political context. It was extended to cover so-called gay rights with gay marriage. Okay, and that's not in the Constitution either. And frankly, that was an illegal Supreme Court decision. And in fact, when the Dobbs case was decided, and of course now the FBI claims it's investigating finally how that got leaked. This was the Roe v. Wade case that overturned Roe v. Wade. The left thought that that was the precursor to overturning the Supreme Court decision, which allowed for gay marriage, because the Constitution really does not allow for gay marriage. That is the construct. But this case revolves around the fact that, after the riots that occurred, in the Midwest with regard to what's his name?
George Floyd.
Floyd, yeah. Black Lives Matter then descended on Washington and started defacing many of the buildings and the streets and everything else, with their graffiti and their slurs and God knows what. And the mayor, of course, Miriam Bowser, was quite supportive of that. She's an ultra leftist, she's Black, and she allowed that to happen. Well, then there was a Black group that came along called Black Lives for the Unborn, okay, something like that. And they wanted just to do it, write a chalk statement on the sidewalk and support a pro-life. And they were arrested by the DC police, apparently on orders from the mayor, Miriam Bowser. So the case came in front of our favorite judge, James Boasberg. And,
sorry, Larry, quickly. Students for Life of America is the name of this organization. And this is a Black and white. This is not a racially oriented organization. They are for, pro-life. They want to abolish abortion, and their primary position here, as I understand it, and I think this is an important conversation to have, is that they are saying that historically abortion and parenthood, whatever that thing is called, Planned Parenthood, has been aimed at Black people and disproportionately results in aborting unborn Black lives. So they're saying unborn Black lives matter, but apparently JEB Boasberg and Muriel Bowser seem to disagree with that.
Well, Boasberg, despite the fact that that group had pled all that it needed to plead, and in the beginning of the case, this case was in federal court, it's 12b-6. You only have to show there's some plausibility in what you're pleading to be able to go forward. You have to accept the allegations in the complaint as true. Now, the allegations here were that there was First Amendment viewpoint discrimination, that because Black Lives Matter, suited the Boasberg and also Bowser, in effect, that was okay. But they somehow got arrested for simply writing in chalk in favor of saving Black lives. And Boasberg dismissed the case. Now, it went up to the District of Columbia Circuit, the federal appellate court, U.S. Court of Appeals for District of Columbia Circuit. That court reversed and sent it back to Boasberg. And here's what's really important about the case, because it's been used both pro and con to conservative and libertarian interests, and President Trump as well, is that what the court said is that if you discriminate on similarly situated matters, that can be a violation of the First Amendment and the Fifth Amendment, and therefore the case should proceed. Now, there was some nuance there with regard to the Fifth Amendment. They found that this group did not plead all that it needed to plead, that they had to show an intent. But with regard to the First Amendment, you don't have to show intent, just that there's that disparity in treatment. Now, this is important because it gives conservatives the right, because, we've been subject to weaponization here. We've been subject to weaponization not just by the Biden-Harris Justice Department, by prosecutors in New York City, in Washington, D.C., in Georgia, throughout the country. President Trump was subjected to that. People that supported President Trump were subjected to that. Bar complaints were filed in the District of Columbia against a number of individuals who support Trump. Yours truly, Rudy Giuliani, Kellyanne Conway, Senators Ted Cruz and Senators Hawley, John Eastman, the law professor who represented Trump in the election dispute, and many, many others. And consequently, we now have a cause of action for discriminating against us, because on the same token, as just one example, the District of Columbia disciplinary apparatus, which is run by far left people from the Democrat Party, they've never given 1 cent to a Republican. They're bringing these cases to try to eliminate conservative and Republican activist lawyers from the practice of law. And Rudy Giuliani has already been disbarred permanently. I've been fighting the DC bar for 14 years. I have 12 lawsuits against them. But Douglas gave me a great way to get after them, and they don't know how to deal with it. They get these compromised judges on the bench that try to throw matters out, but it'll be back. It'll be back. And I even had a hearing today on it. Judge Reggie Walton, who wouldn't allow a particular matter to proceed. And I told him, I said, Your Honor, you're going to be reversed. And he says to me, I have the best record on the bench. I said, well, not when it comes to Larry Klayman, you don't. And
Oh, I'm sorry, I missed that, Larry.
I'll send you the transcript. It was a classic, and I asked him again to recuse himself and disqualify himself from the case. He refused, and he
It's so
stormed off.
funny.
He stormed
I
off.
gotta compliment you here, Larry, because if people haven't had the opportunity to see you in court, it's like the combination of a tennis match, a boxing match, and some kind of intellectual challenge. Because you are fearless with these judges, bantering with them like that. They hate it, obviously, but it's
And I told him,
hilarious.
I said, "On what basis are you dismissing the case?" And he said, "Oh, because you could have brought it in another court." I said, "Well, it belongs in front of your court. This is a constitutional question in front of you, Your Honor, the First Amendment and the Fifth Amendment. And also, I'm asking for damages here because it violated my constitutional rights, which I never asked for in any other court." So I said, "Cite the authority that you have to do this." And he couldn't cite any authority, and just walked off the bench. I mean, this is what you're dealing with. And so, but this does give us an avenue to address the weaponization. And it's a great avenue. And even the DC Circuit, which is very far left, but for the most part, Trump put a few judges on there that aren't, but most of them are. Even they reversed Reggie Walton on this. Not Reggie Walton, James Boasberg, who obviously was sympathetic, more sympathetic to Black Lives Matter than he was to a pro-life group because he's a leftist as well.
Yeah.
So it's a very, very interesting case, and it expands the concept of discrimination that's in the Constitution. It clarifies it that you can reach political and ideological speech which is not meted out equally to the American people.
Hmm. You know, it's interesting, Larry. I was looking at some of the opinions here, and Boasberg, he's a jackass, I have to say. This is his first memorandum opinion, and by the way, the case has been remanded to the district court, so it's going to continue under Boasberg. Everybody knows that he is a member of the Skull and Bones. I just find it interesting. I'd like to know more about how they
Well,
select.
here's what's going to happen. I'll make the prediction now. It was remanded to him. It's currently in discovery. Okay.
Mhm.
And it's been there for a while. He'll find some excuse to dismiss it again. That's
Yeah,
what happened.
exactly.
Years ago, let's get back to Reggie Walton. Okay. I sued OPEC for price fixing and market division. I sought to serve, and a case was assigned to Reggie Walton. The case, I attempted service on OPEC, using court process through DHL, like I have with the Wuhan lab in China and Federal Express. And when they wouldn't accept, I actually went to Austria myself and
Wow.
I served the complaint at OPEC's headquarters. You'll get a laugh out of this. I put the complaint in a wrapper of Playboy magazine.
Oh.
Right? I knew somebody would open it up and read it. And anyway, they still denied service of process. If you can believe this, Austria has a law that you can't serve OPEC in Austria. It's
What?
no accident. Yeah, that was to lure OPEC to Austria, of course. And you know that Austria has a Nazi past. It was more Nazified than even Germany.
Wow.
Hitler, was Austria. You see, the
Wow.
Anschluss, everything else.
That's unbelievable.
So it wasn't an ideological leap of forward by Austria. They were, really kowtowing to OPEC at the time.
But
And so anyway, the case comes back, and I asked Reggie to allow for, I call him Reggie Walton, for alternative service of process. In the meantime, OPEC's law firm, White and Case, had filed a mountain of documents like that, 2 feet high. And I said, you can certainly order, Your Honor, that law firm, one of the biggest law firms in the world, can accept service and be served on behalf of OPEC. And he said no. It went up to the DC Circuit. The DC Circuit reversed them, sent it back, and said, figure out a way that they can get service here. And he dismissed the case again. Okay, this is what you're dealing with Reggie Walton. He's not exactly an honest guy. He's not altogether a genius, let's put it that way. And he's very, very pompous. And you've got a lot of judges there, and I give him credit for one thing, is that nearly every judge in that courthouse is not honest. Okay, it's just a question of degree. It's the worst court in the United States. It's packed with leftists, and even the Republicans, there are rhinos there that are not favorable towards Trump. But here's the irony. is that a judge which Trump appointed, Trevor McFadden, recently enjoined Trump preliminarily from excluding the Associated Press from the press room on the basis that it would not recognize that Trump had renamed the Gulf of Mexico to the Gulf of America. Fadden used Douglas to enjoin Trump, saying that you cannot enjoin them because you cannot exclude them because it's viewpoint discrimination. That simply because you don't like the fact that they accept that you've renamed the Gulf of Mexico to the Gulf of America doesn't give you the right to do it.
Now, wait a minute, Larry.
So
Wait a minute. Wait a minute.
It's now being
Hang on, though. Hang on, though. Because I would challenge that, Judge. This is not viewpoint discrimination. It's a fact that the President of the United States has renamed a body of water. That's not a matter of opinion.
You're right.
This is not.
You're right. You're right.
It's weird.
And it tells you something about, but he still used the same principle. So it's being used both ways. So have other judges in that courthouse. Judge Bates, has used that principle to enjoin Trump recently. And so this is an area which is evolving in the law. I believe that the case I brought against the DC Bar disciplinary apparatus and some of these other cases will go in front of the Supreme Court because this is very important. And it's generally good news. Douglas is good news that we now have a cause of action under the First and Fifth Amendment for discrimination on the basis of ideological and political beliefs if you're being discriminated against in a similarly situated situation, so to speak. So it's a super important case, and we will use that positively from, as conservatives and libertarians and people of faith and those who believe in the vision and creation of our founding fathers.
Larry, it's interesting because the fact pattern that you've just laid out, not in the individual cases, but the responses of the judges, Walton and McFadden and Boasberg, what it really shows us is no matter what sort of legal precedent gets set, these judges will find a way to just sort of do whatever the hell they want with it. Like you were just telling us about your OPEC case with Walton. And we've got this opinion from him here. I just want to read the very beginning of it because this is in my opinion, the style is a very standard, very judicial. It says Plaintiff Freedom Watch instituted this action against the organization of, OPEC. He's laying out the facts. He's giving everybody what's going on. But if we switch over here and take a look at our buddy Boasberg, he is it's almost like he's writing a play. We have different lawyers like Adam Schiff who wish they were screenwriters. Here Boasberg says, large gatherings often spawn expression in a variety of forms. At last summer's protests, sparked by the killing of George Floyd in Minneapolis, there were no exception. Tens of thousands of demonstrators. He's building his case here because he said that these two parties were not similarly situated simply because this George Floyd protest had grown in such a scale and that the size of this Students for Life organization was much smaller. But as you said, the appellate court disagreed that the size of the organization or the size of the protest, the popularity of the opinion didn't matter. And when we look at this other opinion here from Boasberg, it's quite interesting to see that he is, again, being very colorful. He says, with the paint barely dry on its earlier decision in this matter. And he's talking about the paint in the street. He's being very subtextual here in a way that is...
He's grandstanding. He's
right.
He loves himself. He wants the notoriety. He's trying to get himself worked into, the leftist Democrat community and, for all the accolades, the parties in Georgetown and, God knows what else. And recently there was a decision by Beryl Howe in that court. She was chief judge during the witch hunt investigation of Robert Mueller. I asked her to look into the leaks that were coming out. She refused to do that. She had control over that on the grand jury. But she issued a decision recently with regard to the law firm of Perkins Coie, a corrupt law firm, a law firm that, through Mark Elias, laundered money from Hillary Clinton to trigger the Russian collusion investigation, paying for the dossier, the phony fraudulent dossier of Christopher Steele. Now, Trump had the right to remove the security clearances of Perkins Coie and Mark Elias. Mark Elias frankly, is a vile leftist lawyer, knowing no bounds, totally unethical. Of course, the DC bar doesn't investigate him or take any action because he's leftist and they're leftists and they're socialists and they're Democrats. But the special counsel, John Durham, actually found that he had lied, about his actions in that case. And Burl Howe starts off saying, quoting Shakespeare, Shakespeare said, kill all the lawyers. She's very theatrical too. They're really impressed with themselves, super impressed with themselves. And she enjoins Trump permanently from removing Perkins Coie's national security clearances and barring them from doing government business with the executive branch. She can't do that. Now, the same judge, going back several years, throughout a case I filed for Sheriff Joe Arpaio, when Obama declared amnesty for 5 million illegal aliens. And she said, oh, it was just a political matter, I can't reach it. Well, just so happens, I then intervened in a case brought by 25 attorneys general in Texas, and we got the opposite decision. It went to the Fifth Circuit. It was sustained. It went to the Supreme Court. There was a split. And in fact, Obama's amnesty was invalidated because a split goes to, what the Fifth Circuit had done. This is Burl Howe. Okay, so she also used Douglas as a way to enjoin Trump. So now, it's being used by both sides, but these leftist judges, these Democrat judges, pervert the interpretation of Douglas to suit their own ends, you see. But the very fact that we now have this authority is good. And we can find some judges, hopefully, that will, put their foot down and not be like Reggie Walton, who comes off on the bench and says, "I just feel like dismissing it in effect." Or if you don't like it, take it to the D.C. Circuit. And I said, Your Honor, I already did once, and you were reversed then too. That's when he said, "I have the best record of not being reversed." I said, Your Honor, that certainly doesn't apply to Larry Klayman, does it? I said, This case is coming back, Your Honor. It's coming back lickety split, so get ready. And then he wouldn't let me proffer evidence that I had of the discrimination. I said, I think that the D.C. Circuit should see it when they consider my appeal. And I've already appealed it. I appealed it within milliseconds of his ruling today.
Now, we're going to have another opportunity to talk about that. We're almost out of time here, though. People are going to be able to join us on your Substack. People can get onto larryklayman.substack.com. They can find the link on freedomwatchusa.org. We're also going to be, of course, simulcasting on all the Crowdsource the Truth channels on subscribestar.com and patreon.com/crowdsourcethetruth, on Odyssey and on crowdsourcethetruth.substack.com. People who subscribe to me on X will be able to join us as well. Larry, I've got a surprise for you, and it pertains to what you were just talking about with Burl Howe. Just like JEB Boasberg, I am also at it again, Larry. I have filed a application to be an amicus curiae in yet another case. A hypersonic anti-Norm Eisen ballistic weapon has been fired at the ridiculous Mark Zaid versus the Office of the Executive Branch of the United States. These guys, just as you were describing, have complained based on a First Amendment, a completely flawed legal theory that they have a First Amendment right to access classified information, something that falls only and exclusively in the purview of the Commander-in-Chief in the U.S. military. There is no judicial review of presidential decisions with who gets access to classified information. So this notion that Burl Howe could enjoin Donald Trump or any other president is quite ridiculous. We'll just touch on that brief a bit, and I think you're going to find it excellent. We'll be back in just less than 5 minutes